This video is for informational purposes only and is not intended to be legal advice.
Hello there, I'm Joseph Lavelle, and I'm the founder of OregonDivorceForms.com and also the principal attorney of Navigate Legal Services, LLC. I'd like to discuss an article I wrote called, Do I Need a Reason to Divorce My Spouse in Oregon? Oregon is a no-fault state, meaning that you do not need a specific reason to initiate a divorce. However, there may be instances when a spouse's income, social environment, lifestyle, or abusive conduct could affect the outcome of a divorce. As I just mentioned, Oregon is a no-fault state, so all that's needed in your divorce petition is to allege irreconcilable differences, which means that you and your spouse do not get along anymore and you no longer want to be married. In fault states, you must have a reason before petitioning the court for a divorce, such as infidelity, cruelty, or abandonment. When it comes to property distribution and spousal support, spouse bad acts and mistreatment do not factor into the equation. The overarching principle with property distribution and spousal support is that the award should be just and equitable, which is a legal term meaning that the award is fair given the circumstances. The court has interpreted this as what is fair in an economic sense and not for penalizing a spouse for bad acts or rewarding a spouse for mistreatment. The Court of Appeals case, In Re Marriage of Garza in 2005, held that a spouse's domestic violence and mistreatment of the other spouse did not qualify as a basis for spousal support. So what are some situations when a spouse's bad act or mistreatment do factor into a divorce case? Child custody and parenting time are areas that spouse bad acts and mistreatment do factor into the equation. When the court decides which party should be awarded custody of a child between the parents, the factors listed in Oregon Revised Statute, ORS 107.137, are the court's guide. Among those factors is Section 4 that states, the court shall consider the conduct, marital status, income, social environment, or lifestyle of either party only if it is shown that any of these factors are causing or may cause emotional or physical damage to the child. So it is not enough that there is some bad act or behavior that a parent engages in. It must cause or have potential to cause emotional or physical damage to the child. One example of bad acts negatively affecting a parent's custody argument was in Matter of Marriage of Tuma in 1977, where the court found conduct that clearly endangered the child on several occasions, including the parent driving while intoxicated with the child in the car, leaving amphetamines accessible to the child, and holding a marijuana cigarette to the child's mouth. The cases from the Court of Appeals on this issue do not usually explicitly state which acts or lifestyle choices cause or may cause emotional or physical damage to the child. Instead, most have discussed when the trial court applies the factors incorrectly without finding causation or potential to cause harm to the child because the trial court took the harm to the child as a given. The Court of Appeals is making it clear that when the allegation of harm to the child is not black and white and more of a gray area, it requires corroborating evidence and cannot be relied upon if there is no evidence that directly shows damage to the child, such as from a professional to back the allegation. An example of this can be found from a 2015 case where there was evidence of one parent working at a medical marijuana dispensary and using medical marijuana, but without showing how this caused emotional or physical damage to the child. Abuse from one parent against the other parent is an area where custody and parenting time will be affected. Within ORS 107.137, Section 2, it states that if a parent has committed abuse, there is a rebuttable presumption that it is not in the best interest and welfare of the child to award sole or joint custody of the child to a parent who has committed the abuse. The definition of abuse is found in ORS 107.705 and is the standard for granting a restraining order under the Family Abuse Prevention Act. So to conclude, in other states, there needs to be an allegation and evidence of infidelity, cruelty, or abandonment before a party can file for a divorce. In Oregon, this is not the case. Only a desire to no longer be married to your spouse is required, which is called irreconcilable differences. Spousal mistreatment and abuse do not factor into the economic aspects of a divorce, but they do factor into aspects pertaining to child custody and parenting time. If this article helped you understand the divorce process better, consider our divorce form packages that contain forms to begin and finish your divorce in Oregon. Each form contains a video-guided tutorial that you can watch while you fill out the forms. The tutorial explains each entry and also discusses general information on Oregon law, such as how custody is determined, spousal support, property distribution, and more. Each entry also contains written instructions for how to complete each entry, and then what to do with the form after you complete it. Our packages also contain various parenting time plan options, such as a standard parenting plan that contains many provisions often used in family law cases, a medium distance parenting time plan for when parties live more than 60 miles apart, a long distance plan for when parties live more than 180 miles apart, and a safety-centered parenting plan for when there are issues with one parent involving drugs, alcohol, or abuse of the other spouse or children. All right, that concludes my discussion on the article, Do I Need a Reason to Divorce My Spouse in Oregon? I'm Joseph Lavelle, and thank you for following along till the end.